The UK Supreme Court on the 27th of July 2026 unanimously ruled that a Home Office civil penalty notice for employing an illegal worker was invalid. So the Supreme Court quashed the penalty notice. Why? Because the notice listed all three possible legal grounds for the notice instead of specifying which one actually applies in the case. This was in the case of Akbars Restaurant versus Secretary of State for the Home Department, and the case was decided on the 27th of July 2026. So what happened? The Home Office had raided the premises of the employer in January 2023 and found an employee to be working without a permission to work. So the Home Office issued a civil penalty notice under Section 15 of Immigration, Asylum and Nationality Act 2006. Section 15 of this act actually specifies three possible legal grounds on which the Home Office can issue such civil penalty notice. But instead of specifying which one applies in the case, the Home Office listed all three. And so, the problem is in Section 15, subsection CA of the Immigration, Asylum and Nationality Act 2006. Because this subsection actually states that the Home Office must explain why they are issuing the penalty notice. And because the Home Office listed the three possible grounds without specifying which one specifically applies in this case, the Supreme Court ruled against the Home Office. This case had gone through the Court of First Instance, gone through the Appeal Court, and gone all the way to the Supreme Court. That was an employer understanding their right and fighting for it to say no, the Home Office could not rule without a proper legal ground to do so. So the result, the County Court and the Appeal Court had both previously sided with the Home Office. The Supreme Court, however, unanimously reversed both the County Court and the Appeal Court, and the Supreme Court ruled that the notice was invalid. What is the takeaway from this case? When you receive a letter from the Home Office, particularly when that letter has a negative impact on your stay in the UK or working in the UK, you need to take this letter to a solicitor, your solicitor, for proper legal analysis to know what options you have. You might have the opportunity to challenge the decision of the Home Office if the legal ground upon which those decisions are made are invalid. This is my immigration fact check 055. To see 001 to 054, go to my profile. If you want more analysis on UK immigration rules, follow my page. And after that, like this video, share the video with as many people as possible so that they could find it. Save the video for your own reference. And you have a comment or questions, run to the comment box. Thank you, and I'll see you again.